Good afternoon and welcome back to our hearing. Before we begin or pick up where we left off, I'll need for the record to do a roll call for commissioners. Commissioner Belzer.
Present.
Commissioner Howard.
Here.
Commissioner Irvin.
Present.
Commissioner Hamilton.
Here.
We are all here. So I believe we were about to do redirect Mr. Cooper with Mr. Hammond.
Thank you, Mr. Chair. Mr. Chairman, over the lunch break, I had a chance to think about this some more, and I think I don't have anything further from Mr. Hammond and would ask that he be excused.
Okay, Mr. Hammond, thank you for being here today. Thank you for your testimony, and you may step down and be excused.
Thank you. Take care.
Thank you, sir. Okay, Mr. Cooper, I believe we're to Mr. Raftery.
Thank you, Mr. Chairman. Mr. Chairman, Dominion Energy calls John H. Raftery to the stand.
Okay, Mr. Raftery, will you please raise your right hand? We'll get you sworn in. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay, Mr. Cooper, you may begin.
Thank you. Mr. Raftery, please state your name for the record.
John Howard Raftery.
And by whom are you employed and in what capacity?
I am the Director of Rates and Regulatory for Dominion Energy, South Carolina.
Okay. Have you prepared or caused to be prepared under your supervision direct testimony of 14 pages that was previously filed with the Commission on June 30th, 2020 in this docket?
Yes, I have.
Do you have any changes or additions to your pre-filed direct testimony?
No, I do not.
If I ask you the same question today, would your answers be the same?
Yes, they would.
And there are no exhibits to your direct testimony, correct?
That is correct. No exhibit.
Okay. Mr. Chairman, at this time, I move that the pre-filed direct testimony of John Raftery be admitted into the record as if given orally from the stand.
Mr. Raftery's pre-filed direct testimony will be entered into the record as though given orally from the stand.
And Mr. Raftery, have you prepared a summary of your direct testimony?
Yes, I have.
Would you please deliver it at this time?
Yes, thank you. Good afternoon, Chairman Randall and members of the Public Service Commission of South Carolina. My name is John Howard Raftery. I provided direct testimony in this docket on June 30th, 2020, and I respectfully request to provide the Commission with a summary of the same. Prior to the Commission's adoption of the South Carolina Generator Interconnection Procedures, Forms, and Agreements, the South Carolina Standard, in April of 2016, the only state jurisdictional interconnection procedure in South Carolina applied to generators of 100 kilowatts or less. As such, the South Carolina Standard was developed after the passage of Act 236 to ensure that generators also had guidelines pursuant to which they could interconnect safely and reliably with utilities' transmission and distribution system. I was involved on behalf of Dominion Energy South Carolina, Incorporated, or Dominion Energy, in the development of the South Carolina Standard and participated in discussions with the likes of the Office of Regulatory Staff, the ORS, and utility-scale developers. The South Carolina Standard provides a path for generators to interconnect and operate in parallel with the utility system in a manner that ensures the safety and reliability of the utility system. The safety and reliability rules adopted by this Commission apply to interconnection and parallel operation of any generation on the Dominion Energy system, whether behind the meter or otherwise. Section 1.1.1 of the procedures in the South Carolina Standard mandate that the South Carolina Standard apply to the interconnection and parallel operation of generating facilities with utility systems in South Carolina. These requirements are echoed in the interconnection agreement in the South Carolina Standard. Section 1.2 of the Commission-approved Form Interconnection Agreement mandates that the terms and conditions therein are applicable when an interconnection customer's generating facility will interconnect with and operate in parallel with the utility system. It is my testimony today, based on my knowledge of and familiarity with the South Carolina standard, that the interconnection of Bridgestone America's Tire Operations, LLC, or Bridgestone, proposed generating facility falls squarely within the jurisdiction of the South Carolina standard. Any other interpretation or waiver of the South Carolina standard related to the generating facility would necessarily have detrimental effects to the renewable energy in South Carolina, the renewable industry in South Carolina, as evidenced by the letter submitted by the South Carolina Solar Business Alliance, the SC SBA, in this docket. The SC SBA's request that the Commission ensure a non-discriminatory
Objection, Mr. Chairman.
Yes? Who was that?
Scott Elliott. Yep,
Okay.
sorry, this is Scott Elliott. I object to any testimony concerning this letter. It's not in the record. I've moved to strike it. I would object. I would renew my objection to bringing this hearsay document into the record. Thank you, Mr. Chairman.
Mr. Chairman, this is Ashley Cooper for Dominion Energy. I'd be
Yes,
happy to
sir.
respond.
Okay.
This letter, although inconvenient, was filed in this docket, and the Commission as well, within its purview, to take judicial notice of the letter. The letter also out there, this is how we put it into the record, is introducing this on direct. Now, this is a summary, and we have to follow these rules, which are a little bit different, but this is how this is another way to put the letter in this record. So it's perfectly appropriate for us to advance the discussion of this letter at this time.
Okay, after consulting with Ms. Wessinger Hill, we're going to take it under advisement. We're going to rule on it in the order.
Thank you, Mr. Chairman.
Okay, this is John Raftery. I'll continue with my summary.
Go ahead, Mr. Raftery.
Thank you. The SCSBA's request that the Commission ensure a non-discriminatory interconnection process that engenders fair access precisely describes the way in which Dominion Energy is required to manage the state interconnection queue. As such, any waiver or exemption provided to the generating facility would severely threaten the fairness of the process, and that is why Dominion Energy is unable to grant special treatment under the South Carolina standard to Bridgestone, given that it seeks to interconnect and operate in parallel with the Dominion Energy system. Dominion Energy has made this position clear since the moment it required Bridgestone to submit an interconnection application for the generating facility in February of 2018, and Bridgestone proceeded to construct the generating facility with full knowledge of Dominion Energy's position. Indeed, Dominion Energy advanced that exact position to Bridgestone numerous times in an effort to educate Bridgestone on the fundamentals of the generating facility, which trigger the jurisdiction of the South Carolina standard. In response, Bridgestone time and time again refused to cede any ground and instead advanced several novel, incorrect theories to justify its position that the South Carolina standard is simply inapplicable to the generating facility. Dominion Energy set forth the same position to the ORS on May 29, 2018, in responding to a utility services request it received from the ORS. In its response to the utility services request, Dominion Energy stated that the generating facility must be studied in accordance with the South Carolina standard because it seeks to interconnect and operate in parallel with the Dominion Energy system. Dominion Energy again reiterated its position to Bridgestone in a meeting with ORS, Bridgestone, and Dominion Energy on June 26, 2018. After attending the meeting and listening to the ORS state its belief, I became ever more convinced that Dominion Energy must process Bridgestone's interconnection request under the South Carolina standard in accordance with this Commission's rules. Bridgestone again refused to acknowledge the applicability of the South Carolina standard. Although Dominion Energy is required to process the generating facility's interconnection request in a fair, non-discriminatory manner under the South Carolina standard, the Commission could permit the generating facility to bypass the projects ahead of it in the queue and proceed immediately to a safety and reliability study, interconnection, and parallel operation with the Dominion Energy System by granting a waiver. However, precedent from Federal Energy Regulatory Commission or the FERC should be limited in scope and based on an established public interest, such as grid security, national security, or a resultant benefit to customers as a whole, not simply one. To be clear, no such interest exists here, given that the generating facility would only benefit Bridgestone in its effort to achieve corporate sustainability goals and reduce its energy expenses. As such, Bridgestone's waiver request rises nowhere near the public policy interest required by the FERC and certainly does not contribute in any way to grid security. Finally, given the safety risks and reliability risks associated with the operation of this generating facility, Dominion Energy wants to be clearly heard that this generating facility should not only be processed under the South Carolina standard, but also in a manner that is non-discriminatory to other generating facilities that submitted their interconnection requests to Dominion Energy well before Bridgestone. This concludes the summary of my direct testimony. I appreciate the Commission hearing it.
Thank you, Mr. Raftery. Mr. Chairman, Mr. Raftery is available for cross-examination by other parties and questioning by the Commission.
Okay, thank you. Okay, Ms. Lee.
No questions. Thank you, Mr. Chairman.
Thank you. Mr. Knowles.
No questions. Thank you, Mr. Chairman.
Thank you. Mr. Elliott.
Mr. Chairman, thank you. Mr. Raftery, Mr. Chairman, may I cross-examine this witness subject to my ongoing objection as to the admissibility of the testimony about which I'm about to cross him?
I'm going to let Ms. Hill, Ms. Wessinger Hill, talk to you about that. And we need to get you closer to your microphone too, Mr. Elliott. You're kind of weak sounding.
Mr. Elliott, the commission has ruled that they have taken your motion to strike under advisement and will rule on it later. You may do so without waiver of your motion to strike.
Thank you so much. Mr. Raftery, the letter that you reference in connection with the South Carolina Solar Business Alliance, it nowhere in that document states that the Bridgestone solar array will net meter or export power to the grid, does it?
If you'd like to give me a minute, I'll read it in its entirety, but I can't tell you off the top of my head.
All right, I accept your answer. I'm not asking you to read it in its entirety.
Okay.
Nowhere in the letter does the South Carolina Solar Business Alliance state that the Bridgestone solar array is interconnected to Dominion's grid, does it?
I'm sorry, Mr. Elliott, I'd have to give you the same answer. I'd need to read the entire letter in order to answer that properly. I have not committed this to memory.
Yes, sir, I understand. And last, nowhere in the letter does the Solar Business Alliance inform you or the Commission that the solar generator operates in parallel with the Dominion system, does it?
No, as I outlined in my testimony, it primarily discusses non-discrimination and engendering fair access. Those three items that you just brought up are not top of mind to me, so I can't tell you that they're in there or that they're not.
Thank you so much. And Madam Clerk, would you put hearing exhibit number 1 on the Elmo, please?
Okay, if you give us just a moment and we'll get hearing exhibit number 1 there.
It is the letter of Ms. Edwards that Mr. Knowles offered into evidence.
Mr. Elliott, hey, this is Jocelyn Boyd. I need to ask you a quick question. The exhibit number 1 for your client or for the hearing exhibit?
No, it's hearing exhibit number 1. It came in during the opening
No problem.
proceeding.
Yes, sir. Ms. Weeks is about to talk to you.
Mr. Elliott, I have not, nobody handed me that exhibit, and so I have not gotten it from any source to actually mark it as yet. I think it's in the motion to strike, apparently, which I do not have in my materials.
All right, Mr. Chairman, you'll
I
permit-
think we've got a copy here. Hang on.
Thank you.
Okay, we should be coming on to the Elmo.
All right, thank you very much.
Okay.
Would you, Madam Clerk, just scroll to the top so that Mr. Raftery can see the letterhead? All right, Mr. Raftery, I show you hearing Exhibit 1 and ask you if you've seen it before.
Yeah, I have, yes.
It is a letter to R. Ware, Esquire, from Nanette S. Edwards, is it not?
Yes, with the copy to Rodney Blevins.
All right, and let's just get in the record who all these characters are. Ms. Edwards is the Executive Director of the Office of Regulatory Staff, correct?
Yes,
And Mr. Ware was the attorney for Bridgestone in September of 2019, correct?
that is my understanding, but I can't say it with 100% confidence.
I understand, thank you. And last but certainly not least, Mr. Blevins is the President and Chief Executive Officer of DESC, or Dominion Energy South Carolina, is what I understand it is. Is that correct?
He is the president of Dominion Energy South Carolina. He no longer holds that chief executive officer title.
All right, sir, and just to be clear, he is ultimately your supervisor, correct?
Yes, in many ways, yes.
All right, thank you. Now, I will ask you if, to follow along with me, I am going to read the middle paragraph, the second paragraph of this. If you could move it up, it starts contrary. Thank you. Stop right there. That's perfect. Now, I'm merely asking you, Mr. Raftery, if I'm reading this correctly, and you correct me if I'm wrong, because I'm capable of misreading it. Does the letter state, contrary to the statements of Dominion Energy South Carolina, DESC, the South Carolina Office of Regulatory Staff, ORS, does not have the authority or jurisdiction to provide a binding opinion as to whether the Public Service Commission of South Carolina, South Carolina Generator Interconnection Procedures, and the provisions of SC Code Annotated Section 58-27-460, Subpart A, Subpart 1, apply to your client. Only the Commission can issue such a determination or finding. Additionally, ORS lacks the ability to provide a letter of opinion predicting how the Commission may interpret SC Code Annotated Section 58-27-460, Subpart A, Subpart 1. The only recommendation ORS can reasonably provide is that a filing be made with the Commission to obtain the determination that you seek. Have I read that correctly, Mr. Raftery?
I believe you did, yes.
All right. Thank you so much. I have no further questions, Mr. Chairman.
Thank you. Commissioners, questions of Mr. Raftery? Okay. Hearing none, Commissioners, Mr. Raftery, we thank you for being here today. Thank you for your testimony. And we didn't do any redirect. Do we do redirect? We need. Do we need any redirect?
Mr. Chairman, sorry, that with all the confusion, could you give me just 2 minutes to look at my notes? I was starting to scramble when I thought we were going to get left off. Can you give me just 2 minutes?
Certainly. Certainly. That was my exuberance to get to the end.
Mr. Chairman, thank you very much, and I appreciate the 2 minutes. I share your desire, I promise. I'll be very brief.
Thank you.
If I may, Mr. Raftery, I want to turn your attention to the letter that Mr. Elliott questioned you about from the South Carolina Solar Business Alliance. And I just want to read one statement to you because you were talking about some concepts in the letter. And I'm quoting from the letter. However, our members also rely on the fair and non-discriminatory application of the state's interconnection procedures. And SCSBA maintains that unequal application of the law can result in discrimination and a competitive disadvantage for those businesses that operate within the current regulatory rules as adopted by the Commission. Is that correct, Mr. Raftery?
It absolutely is, and I think it's even further than Act number 62.
Thank you, Mr. Raftery. And is it your testimony that following this, the Commission standard has helped promote the large development of renewable generation in South Carolina?
Yes, it has. The standard has provided for a fair, non-discriminatory process for projects to get in queue and get interconnected, which has led to our company and the state being a leader nationally. And so I think it served its purpose very well, but the legislature recognized that there could be even improvement. So that's why in Act 62, it asked the Commission to promulgate further improvements and directed the Commission that those standards be fair, reasonable, and non-discriminatory with the interconnection applicants. It's incredibly important that when applicant doesn't get a leg up from someone else, it needs to be fair and non-discriminatory.
Thank you, Mr. Raftery. And Mr. Chairman, just as a procedural point, I understand that that Mr. Elliott has raised an objection, a motion to strike. So that notwithstanding, I just want to formally, I know that the Commission can take judicial notice of this letter, but I would like to formally request that this be admitted into evidence, just so we don't have any procedural issues down the road, just to preserve all options, Mr. Chairman.
Continuing objection to this line, Mr. Chairman.
Understand. We'll note your objection and we'll enter it as exhibit number 15.
Thank you, Mr. Chairman. And I have just one more set of questions for Mr. Raftery, and I promise I will conclude after that. Mr. Raftery, you were questioned about the ORS letter that was put up on the Elmo. Do you recall that?
I do. It's an incredibly unfortunate letter.
Okay. Mr. Raftery, is it your testimony or that ORS is capable of binding this Commission?
No, not in the least. We were very clear when we went on site with the Office of Regulatory Staff to Bridgestone on that June 26th meeting that I referenced, that neither the company nor the Office of Regulatory Staff could provide any waiver, nor did I ever take the ORS's recommendation or support that the standards apply as a binding requirement. But it certainly did inform my decision that we had landed on the right place, that the standards absolutely applied, and we could not discriminate against others that were ahead of Bridgestone in the queue.
And Mr. Raftery, this ORS meeting you're talking about, this is the same meeting that Bridgestone witness Freeman testified to yesterday, saying that's the meeting when ORS indicated it, explained its position that the South Carolina standard applied. Is that correct?
Yes, I think his exact words were they supported Dominion Energy's stance that the standards applied.
And finally, Mr. Raftery, is the head of Rates and Regulatory, whether ORS was correct or not, listening and attending that meeting, did you feel an obligation to continue to push for the the application of the South Carolina standard after attending that meeting?
It absolutely did affect me. I thought we came to the right conclusion, and I still maintain that today. With the Office of Regulatory staff coming to the same conclusion, it ever more so solidified that we were doing the right thing.
Thank you, Mr. Raftery. Mr. Chairman, I have nothing else.
Okay, thank you. Any recross?
No, thank you, Mr. Chairman.
Thank you.
And Mr. Chairman, I
Yes.
simply ask if Mr. Raftery may be excused.
Mr. Raftery, you may step down and you be excused. Thank you.
Thank you, Chairman.
Okay, anything else to come before us before I'm going to turn it over to Ms. Wessinger Hill in a second. I do want to say one thing in these virtual hearings. It gives us some interesting dynamics. And Mr. Cooper and Mr. Elliott, I don't really mean this statement is complimentary or derogatory to either one of y'all, but you sound alike. Y'all both have very similar speaking sounds, and there were a lot of times when I didn't know who it was talking until you said who you were. So that was the first time I've had that happen. But anyway, Ms.
Mr. Chairman, this is Elliott. I'm flattered.
Well, that's a good thing. We'll all sing Kumbaya in a little while. Ms. Wessinger Hill, if you will take over, and with I think we've got the list of exhibits and proposed orders.
Yes, sir. Thank you, Mr. Chairman.
Mr. Chairman?
Yes.
Mr. Chairman? I'm sorry to interrupt both you and Ms. Wessinger Hill. The parties had contemplated closing arguments, I think. I know that I had, and I know that I'll speak for Ms. Lee. Not sure about Mr. Cooper, but would the commission entertain closing arguments?
I can't imagine you got anything else to say, but we certainly will. We will hang on one second.
I would go the same.
Okay. All right. If we'll do closing arguments, if Mr. Cooper, if you want to have a closing argument, and then we'll go. Mr. Elliott, you have the burden, so you get the end.
Thank you, Mr. Chairman. I would appreciate the opportunity to offer a closing statement if others are doing so.
Go right ahead.
Briefly, sorry, Mr. Chairman, this is Kate Lee with
Yes,
Southern
ma'am.
Environmental Law Center representing the league. We would also like to make a closing statement.
We will. Okay. So hang on one. Let me just make sure I get the right order here. Okay, we'll go Mr. Cooper, Ms. Lee, ORS, if you want to make a closing argument, and then we'll go to Mr. Elliott. Okay, so Mr. Cooper, go right ahead.
Thank you, Mr. Chairman. I'm going to make sure my video is turned on so you know it's me talking. Mr. Chairman, in appreciation for you and the commissioners, we appreciate your time. We appreciate you paying attention and listening so closely to what is a very detailed and complex, at times, discussion, although at other times it's a very simple and straightforward discussion. So we appreciate your time and your attention to this matter. Out of respect, I will try to be very brief with these closing comments. Mr. Chairman, what do we know from the record? We know that Beto is proposing a large utility-scale generating plant with the same safety and reliability concerns and risks as any other utility-scale generating plant. Bridgestone witness McGavran described Bridgestone as a complicated, large industrial system. We know from the record that the solar generating plant will be interconnected with the Dominion system. Even Mr. McGavran, when I talked to him on cross, admitted that it was only isolated when you considered the load of the manufacturing plant along with the reverse power flow relays, suggesting this is an interconnected plant. If it wasn't, you wouldn't need to consider those other things. It will operate in parallel. It is not the sale of power, and the sale of power is not the same as the flow of power. This is a plant that will interconnect and operate in parallel, and it is therefore subject to the South Carolina standard, which this commission adopted that has successfully allowed for the deployment of renewable energy in a safe and reliable manner. As such, this large-scale utility project should be studied to ensure safety and reliability as any other generating plant. Despite being told that the South Carolina standard applied not only by Dominion Energy, but also according to Bridgestone's witness Freeman by the ORS, Bridgestone went ahead and built its plant. Mr. Cassis's letter was introduced earlier today, and Mr. Cassis was very clear. Interconnection of the asset is prohibited. Mr. Chairman, there was no green light. Being treated just like any other generating facility that are now connected and operating, or those wanting to be processed by the standard, is the fair way to treat this Bridgestone generating plant. So now I've talked about what the record has shown. Where do we go from here? We have two options. One, we can grant Bridgestone's request, which would mean two things: that this commission does not have jurisdiction and that this plant is not studied. Or the commission can recognize and retain its jurisdiction to oversee the safe and reliable interconnection of generating facilities in South Carolina. Such a finding would allow this generating facility to be studied to ensure safety and reliability. Finally, even if we determine that the rules apply and that the South Carolina standard applies, this commission has the power to determine whether it would like to grant a special waiver or otherwise provide special treatment to Bridgestone to allow it to move ahead of other projects who are waiting in the queue and be processed ahead. Thank you very much for your time and your attention. This concludes my closing.
Thank you, Mr. Cooper. Ms. Lee.
Sorry, I was on mute there for a second. Thank you, Mr. Chairman and members of the Commission. This case boils down to the plain language of your order, number 2016-191, which specifies that the SC GIP applies only to facilities that either net meter or sell their full output to a South Carolina utility. You've heard a lot of testimony over the past 2 days, but it remains undisputed by all parties that Beto's facility will not net meter or sell its full output to Dominion. The SC GIP therefore does not apply to Beto's solar array, and the company's petition should be granted. Now, as predicted, Dominion has put a number of ancillary issues before you, but none of them change the proper outcome of this case. First, Dominion's counsel and witnesses have several times referenced Section 1.1.1 of the SC GIP, which they argue shows that the interconnection procedures apply to all parallel generating facilities. But that section provides that its requirements apply to, quote, the interconnection and parallel operation of generating facilities with utility systems in South Carolina, end quote. Rather than supporting Dominion's claim that interconnection is synonymous with parallel operation, this language shows that interconnection and parallel operation are different and distinct. They're not one and the same. Another portion of Section 1.1.1, again cited by Dominion Counsel, provides that the procedures apply to generating facilities that are interconnecting to utility systems in South Carolina, and which will not sell their output to a different entity from that South Carolina utility. That language at the end serves only to exclude FERC jurisdictional facilities, but for a facility to be included in the scope of the SC GIP, it must still interconnect under the meaning of the procedures. In short, the procedures themselves leave open the question of when a facility interconnects for the purpose of applying the procedures. And Commission Order 2016-191 provides the answer to that question. On page 6 of that order, the Commission provides that any parallel non-utility generator requesting to interconnect to a South Carolina utility system and to either net meter or sell its full output to the interconnecting utility would interconnect under the proposed standard. That language is echoed again on page 9 of the order, reinforcing that the Commission only contemplated exercising its jurisdiction over interconnections to those facilities that intend to net meter or sell the generator's full output to the interconnecting utility. So to be clear, contrary to Dominion's claims, the SC GIP provides no alternative definition for what interconnections fall within the procedure scope, and the SC GIP must be read in conjunction with the order, which is the only document to define the scope of that term under the meaning of the South Carolina procedures. Under this construction, where the SC GIP describes an interconnection subject to those standards, the language in Order 2016-191 would apply, meaning that to be included within the scope of the SC GIP, a facility must either net meter or sell its full output to a South Carolina utility. And to suggest otherwise, as Dominion has, would rob the Commission order of its legal effect, contrary to the well-established principle that has been affirmed in numerous decisions by the South Carolina Supreme Court that Commission orders and the findings within them have the full force and effect of law. The only way to read Order number 2016-191 and the SC GIP that gives the language in both of those documents full legal effect is to honor the order's directive that an interconnection subject to the SC GIP only exists where a facility will either net meter or sell its full output to the interconnecting utility. And again, it is undisputed that Beto's facility will do neither. Again, contrary to Dominion's claims, the conclusion that Beto's facility is not subject to the SC GIP would not result in discriminatory treatment. The law would apply to facilities that fall within its scope and wouldn't apply to the Beto facility because it does not. Nor would it mean that the array would not be subject to any oversight. The array's safe design and operation is required by the terms of the service contract between Bridgestone and Dominion. Dominion's witness, Mr. Furtick, testified here today that Dominion can do whatever studies it needs to do under the terms of its contract. Now, the Commission may well wish to establish standards for non-exporting generators in the future, perhaps by following other states and adopting expedited procedures for those facilities. But the venue for that decision is not this case. It's the generic docket already underway. As to Beto's solar array, the decision before you today is whether the existing South Carolina interconnection procedures apply. And under the terms of your order number 2016-191, the answer to that question is no. And so we respectfully submit that Bridgestone's petition should be granted. That concludes my statement, and thank you again for all of your time.
Thank you, Ms. Lee. Hey, Mr. Knowles, anything from ORS?
Thank you for the opportunity, Mr. Chairman, but yeah, nothing from ORS.
Thank you. Okay, Mr. Elliott.
Thank you, Mr. Chairman. The Dominion witnesses were really pretty hard on their customer, Bridgestone. The Dominion witnesses used terms such as evade, avoid, skirt, special treatment. I think it's important as we conclude this two-day-long hearing to remind the Commission who Bridgestone is. The record will reflect that Bridgestone owns 2 tire manufacturing plants in Aiken County. The 2 plants together have over 90 acres of manufacturing under roof. Together, the plants employ over 2,200 people in Aiken County. It is a taxpayer, it's a good corporate citizen, and it doesn't deserve the kind of treatment that it's gotten from its energy provider here. In 2017, Bridgestone attempted to develop renewable energy. Bridgestone was beginning to set renewable energy goals, and Dominion had a very good offer, the buy-all, sell-all tariff, whereby Bridgestone could build a solar array, interconnect it to Dominion's distribution line in the vicinity, operate it in parallel, and sell all of its energy to Dominion at a very, very competitive rate. And I would submit that the rate was probably so competitive that that Dominion ultimately sought in 2017 to close the tariff. But as these corporations evolve and our state's manufacturers evolve, Bridgestone also evolved with respect to its renewable energy goals, and Bridgestone's renewable energy policy has become more aggressive over time. And so in 2018, even after the disappointment of not being able to participate in the buy-all, sell-all program, Dominion sought to build a 1.98 megawatt solar array. It was designed to provide electric service only to Bridgestone, only to the plant. The facts bear out that under even the most extreme circumstances, Bridgestone's power consumption, remember they've got 90 acres under roof, would consume every bit of the solar array and would require electricity from Dominion. And again, Bridgestone sought to work with Dominion to get the requisite authority to build and operate this plant. Now, initially, Bridgestone was informed by Dominion that the 1.98 megawatt plant, subject to this litigation, was subject to the fast track program. And the fast track program is exactly that. The deadlines are shortened. There is no lingering stay in a queue, and the authority to construct and operate the plant comes relatively quickly. Now, what we know from Hearing Exhibit 13 is that Bridgestone, in its effort to build this plant, was in full cooperation with Dominion. Bridgestone contracted with Solar Alliance, a solar energy consultant, and an engineer for the design and construction of this plant. We know from Hearing Exhibit 13 that Dominion was fully aware by March 22 of 2018 of the specifications of this proposed solar array. The email from Mr. Hamilton to Dominion witness Hammond describes the conversations that the parties had and offered to meet Dominion's concerns by installing a Multilin 350 relay with reverse power protection. This was at Dominion's insistence. Matt Hammond, on behalf of Dominion, responded by saying, well, you know, there is one other key consideration we must investigate and accommodating the 115 kV auto switching scheme. But he obviously thought that that was a matter that could very easily be accommodated, because he wrote, and I quote, Hearing Exhibit 13, if we're definitely headed down this path, we'll start working on an IA and a refund of the $500 fast-track processing fee. The IA is the interconnection agreement, and as we learned during this hearing, the interconnection agreement is one of the final steps. in the interconnection process. We also see where Mr. Hammond admitted that no further investigation would be needed because he was prepared to refund the $500 fast-track processing fee. They were simply going to ink an agreement and authorize construction. This is corroborated and borne out by the email of Stephen Scott Bell in Hearing Exhibit 13, dated March 23, 2018, where Mr. Bell sent Solar Alliance and Bridgestone a customer information request to be filled out in order to write the interconnection agreement, the IA. The contact information was simply going to be cut and pasted into the IA. And so by March of 2018, Bridgestone thought this matter was all but resolved. However, sometime after March of 2018, and Mr. Hammond did not indicate when, Bridgestone, Dominion reversed course, determined that the fast-track process never applied to the 1.98 megawatt solar array and required Bridgestone to get in the queue. Now, it's fascinating to me to hear Dominion complain that Bridgestone, throughout this process, until such time as it hired a lawyer, Bridgestone cooperated fully with Dominion. There's no evidence in this record that Bridgestone dragged its feet, that Bridgestone evaded, avoided, or skirted, or sought special treatment. Now, what we find from Hearing Exhibit number 9 is that by September of 2018, Bridgestone had committed so much capital in anticipation of this project that it wanted to go ahead and at least invest the funds for budgetary purposes. Now, Mr. Hammond was clueless about the need for budget constraints, but anybody who's operated a small business would know well about budget constraints. And so it is very easy to understand why Bridgestone might want to capitalize on its existing budget and meet its 2019 budget and try to at least get the power array constructed until it could work out something with Dominion. Now, when you look at Hearing Exhibit 9, you find that it's very, very well crafted, and it contains Dominion's legal position. But I would submit to you that Mr. Freeman would not be able to perceive that, inasmuch as he is not a lawyer and he is an electrical engineer. But what Mr. Freeman was able to see, and this is telling, that the first words on the page from Mr. Cassis, who is an excellent customer service representative, Derek, I am still working to find a way to address the interconnection issue. A reasonable inference, and I would submit to you the only inference from that sentence, is to put Derek Freeman at ease that this matter would be worked out. I know Mr. Cassis, and I think that he was probably being sincere. In fact, I have no doubt that he was trying to be sincere at that time. But this matter got away from him because this application got stuck in this queue, and there it sits. And the evidence will reflect that Dominion is unable to tell Bridgestone when its application will be investigated and considered while in the queue. I would submit to you, Mr. Chairman and Commission, that if the General Assembly had intended to design an interconnection program that would defeat the development of renewable energy, it would have designed the program that Dominion insists is in place now. If you look at Act 236, Act 236 creates the South Carolina Distributed Energy Resource Program. Distributed Energy Resource Program. I'm here to tell you that the average South Carolinian would have no idea what this act was about from the title of the act. But you don't have to look far. If you look down in section 58-39-120, you see that distributed energy resource, DER, means demand and supply side resources that can be deployed throughout the system of an electrical utility to meet the energy and reliability needs of the customers served by that system. Distributed energy is electricity that is distributed to a utility for the purpose of meeting its energy and reliability needs. To be covered under the Act, the generator has to export electricity to Dominion's grid. There can be no confusion about it. When Dominion and Duke came before this commission in 2015, it proposed a standard as follows. And we've all read this, but I'm going to read a little further for you at this time in closing argument. Dominion described the SC GIP that we are considering as follows. The proposed standard would apply to any parallel non-utility generator requesting to interconnect to a utility system and to either net meter or sell its full output to the interconnecting utility. We've read that, we've discussed that before, and Ms. Lee very eloquently read the identical language to you in her closing out of your order number 2016-191. But let's read the next sentence in Dominion's petition to get an understanding of what Dominion's intent was. I read, the proposed standard satisfies Act 236's requirement that the Commission promulgate a new interconnection standard for the interconnection of non-utility generators, 2,000 kW or less, through its inclusion of a fast-track screening process that will allow the utilities to fully achieve Act 236's mandate to promote DER development in the state through their DER programs. And so, Mr. Chairman, Commissioners, the GIP is about non-utility generators that distribute or deploy or export or transmit electricity to Dominion's grid. It can be construed in no other way. To construe the SC GIP the way Dominion does in this case is to lead to an absurd result. Now, it is clear that this solar array neither net meters nor sells any output to the grid. It is not subject to your order, 216-191, and it's not subject to FERC. It could not be clearer. Now, the utility argues that all that's necessary is to show that it's interconnected, the solar array is interconnected, and that it operates in parallel. Well, first of all, the solar array is connected to a substation in the Bridgestone powerhouse. Dominion concedes that point. And so it's not direct, it's not interconnected to the grid. Mr. Xanthakos bravely attempted to connect the dots, literally and figuratively, in his Exhibit 1 to his rebuttal testimony. And it was Mr. Xanthakos' testimony that the interconnection facilities that are controlled by the SC GIP, in this particular case, start at the meter, if you will, Dominion's meter, and travels circuitously throughout the entire Beto plant till it gets to the powerhouse. Now, we know from Ms. Cannon's testimony, and I repeat myself, that building is 64 acres under roof. And so Mr. Xanthakos raises not only some really sort of intriguing ideas, legal ideas, about Dominion's liability under the circumstances for its property leading all the way to the powerhouse, but it also makes no sense. Dominion and Bridgestone have one point of interconnection. Hopefully we're going to learn where that is with the late file exhibit. None of the witnesses that testified today or yesterday could tell you where the interconnection point was. I think it couldn't be clearer that the plant, the solar array, the 1.9 watt solar array is not interconnected. Parallel, I mean, I don't understand their point. If the concept of distributed energy resources is to deploy or distribute or export or transmit electricity from the solar array to Dominion's grid for Dominion's purposes, then their definition of parallel just doesn't make any sense, and it's really sort of childish if you think about it. So I would submit to you that when you examine the purposes of Act 236 and you examine the underlying policy behind your order number 2016-191, the Commission can only come to the conclusion that it came to in its order, and that is that to qualify under the GIP, the non-utility owned generator must either net meter or sell its full output to the grid. Now, Dominion is dead set on denying this authority to operate the solar array, and they have lots of what ifs, and I think the Commission sort of picked up on this. But you know, one witness says, "What if they one day increase the capacity from 2 megawatts to 30 megawatts?" Well, I think the Commission quickly understood that that would be a contractual matter that would be resolved through contract. Well, there was something about flicker. What if there's a flicker? What if there's a malfunction? And again, I think the Commission, through questioning, understood that these electronic systems are complicated, that they are designed by engineers, they're designed by scientists, and they can design to operate as intended. And in fact, we know that the reverse power flow that Mr. Hammond insisted that Bridgestone install at its property actually worked. These complaints are not serious. I would submit to you, Mr. Chairman and lady and gentlemen of the Commission, that the reason that Dominion is fighting this so hard is the result of testimony of one witness that says they've already dragged one similar solar array through the queue, and he is up and operating, and that there's another one in the queue, and that Dominion has allowed this to allow their erroneous view of the SC GIP get them in so deep that they have no way out, and so therefore they're fighting this tooth and nail. In closing, I would submit to you this. On the evidence, the only reasonable legal conclusion you can draw is that to be subject to the GIP, the solar array must net meter or sell its output to the grid. I would submit to you that the only factual result here is that Beto neither net meters nor sells to the grid. The parties have a contract in place. It is a standard contract. The Bridgestone contract has been approved by this Commission. You will find that this is a standard contract for all customers, which has been approved by this commission. This commission has jurisdiction by statute to address contractual disputes. The Dominion has the authority to require Bridgestone to demonstrate that the solar array protects the safety of its equipment, facilities, distribution center, and transmission lines. This need not go through the GIP. The parties concede that they would make the same. The Dominion conceded that it would make the same safety inspection with a waiver as it would make through the GIP. And Ms. Cannon was very forthcoming when she testified to Commissioner Howard that she would welcome a safety and operations check. So, for the reasons outlined, Bridgestone is entitled to an order declaring that its solar array is not subject to the SC GIP, ordering Dominion to make an inspection and examination of the solar array forthwith, and either report to Bridgestone as to what upgrades are needed, or authorize what upgrades were needed within a reasonable time, which I would submit on this record as 90 days. Last, and almost in the nature of a footnote, I understood the testimony of a couple of these Dominion witnesses to all but concede that Bridgestone was entitled to a waiver. Bridgestone would certainly accept a waiver if the terms were reasonable and allowed it to have the operation of its solar array within 90 days, as I've discussed. A waiver certainly spares Dominion any embarrassment over having put other solar arrays in the queue in violation of order number 2016-191. Mr. Chairman, you all have been very patient with me and my witnesses, and I sort of feel like I'm still living in the last century, and you've been patient with me as I try to master your electronics, and I really appreciate it. It's been a pleasure. Thank you so much.
Thank you, Mr. Elliott. Okay. Any other, I think we've asked everyone that might make a closing statement. I think we're done with that. So, Ms. Wessinger-Hill, I'm going to turn it over to you.
Thank you, Mr. Chairman. Just a reminder to council that the proposed orders in this matter are due no later than August the 5th, which is Wednesday a week from today. Also, with regard to, I'm going to go over the list of exhibits, but there are some late filed exhibits that need to be produced also on that, either on or before August 5th as well. It is requested that those late filed exhibits are shared with the parties at least 48 hours in advance thereof. So let's just go ahead and say, please share those with the parties of record no later than Monday, August the 3rd, by the close of business. With regard to that, this is the hearing exhibit list. Hearing exhibit number 1 is the ORS letter dated September 27, 2019. And if there are any objections, let me know, or any differences, please let me know. Hearing exhibit number 2 is Mr. Freeman's pre-filed exhibits, both confidential and public versions, exhibits number A and B. Then we've got hearing exhibit number 3, which are also Bridgestone's. That's the pre-filed direct exhibits of Mr. Freeman. That's exhibit number C, the public version of that. Hearing exhibit number 4, which is Bridgestone's hearing exhibit pre-filed exhibits for Mr. McGarvin. And that is his direct exhibit, Appendix A, and exhibit number 1. Hearing exhibit number 4 is Beto exhibit for the rebuttal exhibit for Mr. McGavran. Also, it is a hearing exhibit. It will be McGavran rebuttal exhibit A. Hearing.
Ms. Wessinger-Hill, may I interrupt you a minute, please?
Ma'am?
I'm sorry.
Oh, I said 4. I'm sorry. That's number 5. Okay, I'm sorry. Hearing.
No. Thank you.
Thank you, Mr. Elliott. Hearing exhibit number 6 is a cross-examination exhibit of Dominion, which was their exhibit number 4. Hearing exhibit number 7 is Dominion's composite exhibits PNX1, PNX2, and PNX3, and those were not confidential. Those were all public versions. Then we have hearing exhibit number 8. That is a reserved late filed exhibit, which is supposed to be the one that is going to be highlighted, showing of PNX number 1, showing the Dominion and also Beto owned facilities are going to be highlighted. That was the request of Commissioner Belzer. Hearing exhibit number 9 is the cross-examination exhibit Beto number 6, which was emails dated 9/9/2008. Hearing exhibit number 10 was a late filed exhibit request. It is information on kilowatt hours. That was a request of Commissioner Howard. Hearing exhibit number 11 is a late filed exhibit referencing the cost of RECs. That was a request of Commissioner Irvin. Hearing exhibit number 12 is the Dominion's pre-filed surrebuttal exhibits of Matthew Hammond, both confidential and public versions. That is MJH1 through MJH4. Then you have hearing exhibit number 13, which was Bridgestone. That is the emails with regard to Stephen Scott Bell between him and Matt Hammond. Hearing exhibit number 14 is a late filed exhibit. This is Dominion, late filed exhibit request per Commissioner Hamilton, I do believe, with regard to information about the queue. Anyone know that was the question about Bridgestone's position on the queue? Then we have hearing exhibit number 15, which is the South Carolina SBA letter dated 4/29/2020. Mr. Chairman, that's all the list of exhibits, and then we've already discussed the proposed orders are due next Wednesday, August the 3rd. Next Wednesday, August the 5th, and then any late filed exhibits need to be exchanged between the parties no later than Monday, August the 3rd.
Great, thank you.
Thank you, Mr. Chairman.
Thank you, Ms. Wessinger Hill. Any questions of anyone? Okay, I want to.
Ms. Hill's right on. Ms. Wessinger Hill's right on.
Right.
Mr. Chairman, this is actually Cooper, counsel for Dominion. I just had one question on the, we obviously would do whatever the commission prefers. On the sharing of the recs, we mentioned that had market-sensitive information. So it would be difficult to share those prices with Bridgestone, but and maybe we could share with Mr. Elliott under a confidentiality order with Mr. Elliott, or was the commission just intending us to provide this information to the commission?
That was to be provided confidentially, and that needs to be just shared with the commission.
Thank you very much.
And, wait. And you also need to share it with the parties. They've already entered in. Have you not already entered in a confidential agreement with all the party council?
We have it. It's just we have it. It's just that it would be maybe it's remote. But should Bridgestone want to negotiate rec agreement with Dominion, they would have already they would already have our pricing mechanism, which is normally a bilateral contract negotiation.
And Joanne, this is Matt Gissendanner with Dominion Energy. We also do not have confidentiality agreements in this docket with any of the parties. And to reiterate the point that Ashley made, as we stated during the testimony, those are market sensitive. We negotiate those recs with other parties, and so we certainly, to the extent that Bridgestone approached us and wanted to negotiate those rates, it would be inappropriate for us to share those rates with them prior to that time.
Mr. Chairman, this is Commissioner Irvin, I believe I made the request.
Yes, sir.
And, I would amend the request to allow the company to redact any market-sensitive numbers on the late filed exhibit. If that would satisfy everyone, I think that would be appropriate. I think they offered at one point to provide us with additional information about how that program works, and that I think would be of interest to the commission. If you could at least give us that information, that's what I was more interested in. And obviously, don't need the pricing information.
Commissioners, Ashley Cooper on behalf of Dominion Energy, thank you very much for your clarification, and we'll be happy to provide such information.
Okay, so thank you, Commissioner. So the clarification with that late filed exhibit, hearing exhibit number 11, that will be additional information regarding the RECs. With any
and Ms. Wessinger Hill, a public document, right?
yes, a public document, so any confidential information will not be disclosed.
Thank you.
Thank you.
Okay. Thank you. Thank you, Ms. Wessinger Hill. Thank you, Commissioner Irvin. So are we good on all of those? We're clear on everything? Okay.
Yes, sir.
I want to thank everyone for your participation and for a good full 2 days. I especially want to thank the our technical team, who was really scrambled today because we've been shorthanded on people, but we made it through this and worked it out. So I know Ms. Boyd has probably run 14 miles just from the back of the hearing room to the front and back all day long for the last 2 days, but it has gone very, very well in a challenging situation and a challenging time. I just appreciate the hard work everybody on staff has done to make this work out with the way Ms. Wessinger Hill handled. Ms. Wheat has organized these exhibits where we were able to see them and everybody was able to share. And I appreciate the patience of all the parties to give us a second every time when we were trying to make sure we had everything set up in a way that would be beneficial to all. So just kudos to everybody that's worked hard on this. We thank you all for your participation, and if there's nothing else to come before us, we are adjourned. Thank you.